Hello all. Today we shall begin with fundamental right. It is part 3 of the constitution and it contains article from 12 to 35. Before that, let us see the origin of fundamental rights. It is based on Bill of Rights of US Constitution. Why fundamental rights? FR here means fundamental right. It is essential for an individual to achieve its potential. It is essential for functioning of democracy. It is essential to protect citizens from tyranny of states. These rights or claims are demanded on society or government, ensured by the law on just, fair and reasonable basis. Now let us look at the constitution. Article 12 states that in this part, unless the context otherwise requires, the state includes the government, Parliament of India, government and the legislature of each of the states and all local and other authorities within the territory of India or under the control of government of India. Here it defines what is a state. The more clarity we'll get from the Supreme Court judgment, let us see what is not state. In Chandar Mohan Khanna versus NCRT and others, in 1991, Supreme Court held that NCRT is not an state as defined under Article 12 of the Constitution. National Human Rights Commission is a state because its members are appointed by government and it receives funding from the government. In G Telefilms Limited versus Union of India 2005 case, Supreme Court held that BCCI is not state under the ambit of Article 12. In Sukhdev Singh versus Bhagat Ram 1975 case, Supreme Court held that LIC is a state. Okay, so these are the things which pertains to Article 12 but not given in the Constitution. It helps in enriching your answer or sometimes solve an MCQ. Now Article 13. Before that, let us see that fundamental rights are enforced against state. State in legal sense means a country, sovereign country, that is India. In federal sense, a unit of federal state. In administrative sense, any authority that exercises government function or executive function like government, example public sector undertakings, nationalized banks, they fall under the ambit of state. Panchayats. Now the question arises, is judiciary a part of state? That is, answer is both yes and no. Both are correct. If judiciary performs judicial function, it is not state. If judiciary performs administrative function, it is a state. Administrative functions like recruitment, rules, notification, so it forms state. Let us look at the nature of fundamental right enjoyed by citizens, that is all fundamental rights, while some fundamental rights are enjoyed by foreigners also. Enforceable against state. A state as defined in Article 12, it imposes duty on state to respect the fundamental rights of individual. Fundamental rights are negative obligations of state. ना चाहते हुए भी इनको प्रोटेक्ट करना है fundamental rights. It is limitation on the powers of the state. It supports doctrine of limited government. You can write it protects citizens from tyranny of states. Fundamental rights are not absolute. Article 13. Laws inconsistent with or in derogation of the fundamental right. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. Meaning, suppose given a law, there will be different sections of it. If a particular section is violating fundamental right, only that section will become inconsistent. Preferably, it is talking about the laws which are before the commencement of the constitution. Like we have borrowed Indian Penal Code from British India. So if certain part of that which are inconsistent will be invalid. The state shall not make any law which takes away or abridges the rights conferred by this part. Means part 3, some rights which are conferred by the part 3, state cannot make law to take away the right. So basically here the definition of law is there. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom is also mentioned, having the territory of India. Article 13 basically gives judicial review power to Supreme Court. So this is Article 13. Now starts the Article 14. Look, the state shall not deny any person. Any person it's saying, means if it is saying any person, it is available to citizens plus foreigners. Okay, equality before law or the equal protection of law within the territory of India. These are the two things. Equality before law is one thing, and equal protection of laws. These are the two different things. Let us understand that. By the way, Article 14 forms the part of basic structure of Constitution given in Indira Sahani case. Equality before law and equal protection of law. The concept equality before law originated in Britain. It conveys negative meaning, suggests absence of privileges, which means no special favor in the eye of law. It was given by A.V. Dicey and used equality before law to explain what is rule of law. Example, that absence of privileges or no special favor. Special case for a special court is allowed, while a special court for special people not allowed. This was violated once during Indira Gandhi tenure.